Welcome back to the last lecture in this series. I'm going to be talking about clinicians in court. Probably out of all the lectures that I've given you, this one is, for me, the most essential. There is very little information I find that's available and useful for mental health counselors, for mental health professionals, that talks about the experience of being in court in a realistic and down-to-earth way. I have been very, very fortunate as a psychologist to have been involved in seminars and also to have found books that talked about this realistically, and I want to share that information with you. Hopefully it's helpful to you. It's also a part of the practice that is not discussed much in schooling or in your work experience. You're thrown into it and expected to be able to function, and that's a horrible way to learn to swim in the court system, being thrown into the deep end of the pool. So bear with me. Hopefully I give you some skills, some survival skills to get through the court system, and we'll go from there. One of my experiences, one of my stories that I love to tell is about an early experience, fairly early in my career, being on the stand. This is a jury trial. This was a judge who was later removed by the state of Indiana. But it didn't change the fact that he was on the bench for a number of years, long before his removal and long before he should have been removed. I am testifying in a trial for a person who had sexually offended. I'm on the witness stand. To my immediate right is the defendant and his attorney, and then directly in front of me is the prosecutor and a female sergeant who has been responsible for much of the investigatory effort in this case. So they're sitting at the prosecutor's table. The question comes from, I believe, the prosecutor. And I've forgotten honestly what the question was, but it was an innocuous question leading the testimony forward. And before I can answer, the judge interrupts me. And he says, "Just a minute, Dr. Cates, just a minute. I want to make something clear to the jury. You might walk into a room and see Sergeant," and he called the female sergeant by name, "naked lying on the floor. And you might see me lying naked on top of her. And you might assume that we were having sex. Well, that's not necessarily true. Go ahead, Dr. Cates, answer the question." The sergeant was livid, and I was seriously looking at her, wondering if she was going to pull her gun and shoot the judge right there, because that was the look that was on her face. The prosecutor is rolling his eyes. The jury is clearly looking at him like he's lost his mind, but also looking like this has been going on across the 2 days of the trial where I haven't been there. And I am trying to collect myself, remember what the question was, trying to decide if this has any relevance to the question, which it obviously doesn't, and decide how to move forward in my testimony. Now, the purpose of that story is to tell you that's the most outlandish thing that's happened in my years of testifying, but it's in some ways by a slim margin the most outlandish thing that's happened. Believe me when I tell you that the courtroom can become a circus very quickly. So be prepared that no matter what you think is going to happen in the courtroom, it may not necessarily happen that way. Courtrooms are strange places. People are tense, people are on edge, people who deal with them all the time become bored with them and look forward to a little change of pace. They're an odd animal. And no matter how much you think you're ready for what's going to happen in court, you're not. That's the moral of that story. All right. As far as my background goes testifying in court, I have testified in a variety of settings. Some relate to psychological testing, some not at all. I've done review hearings for placement, for foster children, for residential placement. I've done hearings for competency to stand trial, for insanity defenses. I've been in murder and manslaughter trials rather. I've testified in rape cases, burglary and theft, custodial and visitation cases. I've done sentencing hearings. I've even done one slip and fall for a large company. I only did it once because I really don't enjoy those kinds of things, but I did it to see what it was like. And a slip and fall is simply a woman accused a large company of being negligent, and she fell and injured herself in their store, and so was doing a lawsuit. So I got pulled into that one. I've testified in open court with the public present. I've testified in closed court for juveniles where the courtroom was closed off and sealed. I've testified in jury trials. I've testified in bench trials where it was just the judge. I've testified in depositions. And depositions simply mean that there is a court reporter, there is the opposing attorney and the attorney. There can be a guardian ad litem if that has been appointed when there are children involved. The parties can be present for a deposition. They don't have to be, but those are the only persons present, and it's more informal than a courtroom setting. I've been asked to lie. I've been asked to participate in unethical practices. I have been cross-examined by the judge. Now, it's fine for the judge to ask questions about what's going on, but I've been literally cross-examined by the judge. I've had information gleaned by attorneys in other venues other than the court setting, and then used it to challenge me in a current court case, which is, again, unethical. I've been treated like a king. I've been treated like dirt, sometimes by the same attorney, in the same hearing, or the same proceeding. And I return to court again and again, not because I like it, but because I truly believe that it's one of the areas of my life where I have something to contribute. And so that's why I keep going back. And note that I'm going to relate the stories of my own experience today throughout, and the purpose in that, or the purposes are several. First of all, hopefully to entertain you a little bit and keep the topic from getting too boring. But I also want to point to some of the idiotic things I've done in court and survived and even maintained a reputation, so that you know when you go to court, if you do something that you feel like is just, oh no, you survive it, you get through it, everybody does. And to humanize the courtroom experience to some extent, so that you can feel like it's not this horrible, death-defying experience that can create a phobia for you, as it does for at least some percentage of mental health counselors. And maybe, just maybe, to encourage some of you to contribute your expertise to the legal system as well, and begin to be courtroom advocates. All right. I think there are developmental phases of court testimony. And I call phase one the measured for the drop phase. And at this point, it feels as though the hangman is measuring you for the drop before you go to court. It is terrifying. It is a chore. It is an onerous, awful chore. I used to hate to raise my hand to take the oath before I was sworn in because my hand was shaking so badly you could see it. Truly, absolute truth. Phase two I call the dueling banjos phase. If you remember the movie Deliverance, and dueling banjos there. And I'm out of my element in that phase, but I'm beginning to enjoy the sparring, the competition with an attorney. Even though the competition was in someone else's territory entirely, I still enjoyed walking in and knowing that I was going to be able to match wits and see what happened. toward the end of that stage, I actually got to the point where I was bored with the direct examination. I was bored with laying the groundwork because I wanted to get to the cross so I could argue with the attorney who was trying to bring me down. And then comes phase 3, the Rocky phase. I call it that from the Rocky movies. And I began to feel like an underdog who could take on the crazy system and win. You know, I was in there, and by God, I'd show them that I could really succeed in this thing. The danger here is you can end up in Rocky Horror instead of Rocky, because you get too confident, you get too cocky, and someone will bring you down in a big, big way. Right? The greatest incident I can think of that describes that. I had a judge who was willing to let things go. Very laid-back judge. I had one attorney that was actually appearing for her. She had never heard the word object and never objected to anything anyone said, and I had an attorney on the other side who was an absolute bulldog. So the attorney on the other side starts to ask me about my personal life. This is a custody evaluation. And he's asking about my marriage, whether it was my first marriage, and those are really out of bounds questions. And so I turned to the judge and I said, Your Honor, I'm really uncomfortable answering these questions because the attorney wasn't objecting. And the judge said, well, we'll give him some leeway. This is not what I wanted to hear. So I'm very reluctantly and very tersely answering these questions. Well, the attorney now smells blood in the water. He feels like I've got something to hide. So he's asking about cohabitation and divorces and things that are really none of his business. But he gets back around to how many children I have and whether, what my relationship is like with my children, how I discipline my children, just totally out of bounds. And so I got tired of it, so I started asking him, how many times have you been married? Are you married now? How many children do you have? And in one of the more bizarre moments in a courtroom I've had, he begins to answer me. He's answering my questions off the witness stand about his marriages, his children, everything else. And I finally just sputtered to a stop. But it was totally inappropriate. It was totally out of bounds for me to be asking him questions as a witness, much less for him to be answering. Not only, just to mention, it's totally out of bounds for the other attorney not to object to any of this and for the judge to allow this to go on. But again, in court, sometimes things happen. And the whole exchange ends up making the attorney and me both look like fools. But there it goes. When you're in the Rocky phase and you think you're going to take them on, that's where you can end up. Phase 4, the advocate phase. And I begin to identify in that phase, and I think those of us who really do well when we go to court end up in this phase. We're non-adversarial advocates in an adversarial system. And the experience that truly propelled me into this phase, and I ended up testifying at a sentencing hearing. And I was in my early 40s. And the defendant happened to be exactly my age. And I had the experience of leaving the courtroom. I stayed to see what the sentence would be, and he was sentenced to 20 years. So even at that point in time, with good time, 22-10. So he would be in his early 50s by the time he got out. And I happened to end up in the elevator with him and the deputy as he's leaving, and he's chained and manacled and the whole 9 yards. But I'm riding down in the elevator with him, and we're obviously not saying anything to each other, but I'm thinking, we get off this elevator, and he gets back into a van and goes to the jail and from there goes to prison. And for the next 10 years of his life, that's where he's going to be. And for the next 10 years of my life, I'm going on living. Wow. What an incredible difference in the way our lives are going to be. And granted, he made choices that led his life to be where it is. But it was a powerful moment. And I thought about, what am I doing? You know, this is an adversarial system. But how do I advocate? How do I stand as an advocate in this system for the best treatment, the best rehabilitation option, the best services possible? And that's what I need to be doing. Punishment, in my mind, is not an ethical concern of mine as a mental health professional. Punishment is a matter for the citizens of the state of Indiana to decide. So as far as the adversarial system and punishment goes, not my concern. My concern as a mental health professional is, what are the needs of this person within the judicial system? And that's what I can address, and that's what I do address. So with that in mind, what become my fundamental considerations in testimony? One of them is the concept of justice and procedural fairness. In our judicial system, we talk about stare decisis, and that's the idea that like cases are treated alike. So hopefully, we're seeing like cases treated alike. Judges are guided by precedents, legal principles established by higher courts or laws or previous case laws, so that similar cases are decided in similar manners or treated in similar manners. Still, there's judicial discretion that allows cases to be treated equitably rather than equally. And there are procedural rules that are designed to maintain the fairness of the process. Procedural rules maintain the fairness of the process. And that's your first lecture question. What do procedural rules do? They maintain the fairness of the process. The adversarial process that I'm talking about is a foundation of the court system in the United States. And there's recognition that the adversarial process is effective in criminal law and in civil law, if we're talking about lawsuits, those types of things. It may not be most effective in family court and in juvenile proceedings, but efforts to revamp it have fallen short of actually eliminating the adversarial nature of the judiciary. Probably the closest we've come are drug courts, but even those still have their flaws. The underlying premise of the adversarial process is that each side presents its strongest case and attempts to challenge or undermine the case of the opposing side. And in this process of presenting the strongest case, challenging or undermining the opposite side, the truth will emerge. And the two issues to consider when you become a witness in this process are the admissibility of evidence and the weight of evidence. We'll discuss the weight of evidence in more detail later. So even if it's not directly mentioned, and it usually won't be, because this is a philosophy that undergirds the judicial system, these are inherent considerations that will always be there. Think about for just a second what mental health counselors are doing, what you're doing in treatment, and the process through which you're approaching treatment, and it is so radically different from what you're being asked to do on the stand. This is why we have such difficulty. So how do you prepare emotionally for court? If you have better clarity on your internal attitudes, you're better able to react intentionally to the situation when you're in contact with the legal system. Remember, attorneys are trained in this adversarial approach, these adversarial tactics, and that often leaves us feeling at a disadvantage. So they are willing to battle with colleagues. They are willing to challenge, argue, and play strategic games with the facts. That is not what we're trained to do. We are not trained to battle it out. We're not trained to debate. We're not trained to take a stance and stand behind that stance no matter what, stubbornly. We're trained to mediate, to communicate, to dialogue, that truth is a matter of shades of gray and perceptions, a whole different field, a whole different way of looking at the world. And attorneys will zealously argue for a client's position and work hard at undermining the credibility of the other side. That's what they're paid to do. They're not paid to say, necessarily, my client is an idiot. Now, good attorneys will say, my client has an untenable position, and say to the client, these are the parts of your position that won't work. This is where you need to give and compromise. But if the client is unwilling to compromise, the attorney will go forward and argue for that position regardless. So, I had a consultation with an attorney in a custody case one time. And the adult daughter and a half-sibling were accusing the father of sexual abuse. And I recommended custody of the daughter to the mother. And the father said that the attorney to the father said that the dad wanted to contest the recommendation in court. He knew that it was useless. The attorney knew that this was a useless effort, with the adult daughter and the half-sibling saying that the father had sexually abused them. Two credible witnesses. There was no way that a fight in court was going to win. But the father wanted to fight it in court, so the attorney had to fight it in court, and zealously, vigorously attacked me as a professional and my findings. There was nothing personal about it, and he did not believe the attack he was presenting. But as an attorney representing his client, that's what he had to do. We don't understand that necessarily at an emotional level. How can you do that? How can you go forward and attack knowing that you're going to lose and not believing in the position that you're taking? That's what an attorney is paid to do in an adversarial system. We value empathy, honesty, concern, support. We're trained to be gentle, compassionate, understanding, forgiving, and involve ourselves in constructive communication. And if we do have issues with fellow professionals, rarely do we bring those into the open. We'll talk behind their backs, we'll vent to somebody else, but we aren't real good about saying out loud, this is the problem I have with you. That's just not who we are. We are the absolute opposite of the courtroom experience. We can consider the courtroom experience as creating a form of countertransference. And if we consider for a moment the courtroom drama, if you will, the courtroom drama, as a temporary family system, and you become a family member in that system who has reluctantly been conscripted, you have no power to change the family dynamics. Your only ability is to preserve your own status within this crazy dynamic. Is it any wonder that resentment and anger become problematic? You're conscripted into a crazy, dysfunctional family. You have no power to say anything or do anything other than preserve your own integrity in that family as much as you can, and that's it. Remaining aware of your own emotions in that situation is key, and that will help you balance these. All right. What is our role in court then? One of the primary struggles in the legal system as far as our roles go, become direct and cross-examinations. Usually, not always, usually in direct examinations, we're asked to present the facts as we know them, and it's fairly straightforward. Our role is that of an expert presenting information. You met with the defendant how many times? What was the nature of those meetings? What did the defendant share with you during those meetings? What did you observe about the defendant in those meetings? It's fairly straightforward. In the cross, there's an attempt to undermine or make the testimony less credible. So the role that you're cast in can be that of a charlatan who's attempting to deceive the court. That's not always the case. Sometimes they'll pick out specific aspects of what you've shared and say, I don't believe that that is accurate, or they'll focus on a particular aspect and say, is there another way of interpreting that? But sometimes it's out and out, you don't know what you're talking about, and they'll try to present you that way. Court officers, and by court officers I mean the judge, the attorneys, a guardian ad litem again. A guardian ad litem is appointed for children to oversee the children and the needs and the advocate for the needs of the children, and is usually an attorney. Those court officers are familiar with this duality of roles, and they anticipate it. So they understand what's happening. The clinician, however, does not. And it's extremely disconcerting for us to be attacked in this way. We all can also have to consider adversarial versus collaborative approaches. The manner in which evidence is presented can become all important to the client relationship. So it's important to try to remain factual and avoid appearing as provocative or aggravating or divisive in our presentation. It's very, very easy to become hostile toward someone who's challenging your percepts or your presentation. But in doing so, the client, who is also tense and also anxious about your being there, is hearing you become hostile, negative, confrontive, whatever. And they may be taking that as demonstrating how you feel about them. So trying to remain balanced and matter of fact is important for the client. In doing so, however, even the direct examination can begin to feel more like a cross. For example, I had a custody evaluation one time in which the mother was accusing the father of smoking marijuana. And this was a number of years ago. States weren't legalizing marijuana at that point in time. So there was more of an attitude of prejudice toward it than there is now. The father refused to take a random drug screen for me and admitted, if I take a random drug screen right now, I'll fail because I've been smoking marijuana. I said, okay, how often are you smoking? And he gave me how much he said he was smoking, at least. So, okay. The attorney for the mother, when we get to the custody trial, is desperately attempting on the on the direct. So this is supposed to be the easier of the two examinations. On the direct examination, is desperately attempting to have me characterize the father as abusing marijuana. And I wouldn't do that. Because what I came back to again and again and again, very calmly, was that I did not have enough information about his marijuana use nor did I have psychological testing materials that supported the fact that he was abusing marijuana. I knew he was using it. I knew that he was using it in the face of seeking custody of his daughter, which was probably poor judgment. But I did not have enough information to truly say that he was, categorically say, that he was abusing marijuana. Now, what came out of that was that the mother was angry that I wouldn't say he was abusing, but he actually ended up seeking treatment for drug use because he felt like I respected where he was coming from. And that was a surprise to me. But because I remained balanced and matter of fact, even on the direct examination, which was turning into a cross-examination on direct, was what really happened, it was a win. Because the client felt that I was supportive and respectful of him. Okay, I could have gotten angry, I could have caved and said, yes, it sounds like abuse to me. I could have done all sorts of things, but I remained balanced and matter of fact, and it worked in my favor in that particular case. Clinicians often see the legal process as very rigid and very formal. We're used to talking about shades of gray. We're used to equivocating what we say. And attorneys will view the rules and structure of processes as necessary to ensure that the process is predictable and fair. Remember, we can challenge the rules, but we need to do so in a way that's consistent with the rules of law. So, for example, we can write or call an attorney informally in an effort to quash a subpoena. And quash the subpoena means to stop a subpoena. We can write a judge with the same request if the subpoena comes from the court. Or we can work more formally through an attorney to have a subpoena quashed. All of those things are possible. You can also ignore a subpoena, but I don't recommend that approach at all. All right. On the stand, if you're on the stand, it is permissible, it is perfectly permissible to ask the judge a question about responding. For example, you can say, Your Honor, I feel that to answer that question would violate my client's confidentiality. Am I required to do so by the court? If the answer is yes, you have just been ordered by the court to respond. And you have no choice unless you want to go to jail for contempt of court, or face the risk of going to jail for contempt of court. In depositions, without a judge present, there's generally more leeway. And I recommend in a deposition, if you're in doubt, go off the record and consult with your attorney or the attorney who has called you to the deposition. And if you're still in doubt, explain the reason you declined to answer on the record and let the judge rule on it in court. So there's no problem with going off the record in a deposition. Say, I want to go off the record. The court reporter will stop taping, stop recording what's going on. You consult with your attorney. You can step out of earshot of the other attorney to consult with your attorney, or you can just say with everyone there, I'm not sure I can answer this question. And the two attorneys can bat it back and forth. But you're in control in that situation of saying, I'm not sure I want to answer. If there's no judge there to give you the deciding determination. Issues of fact versus subjective meaning. Clinicians are often accused of difficulty in understanding the difference between fact and speculation. Note as an expert witness You are allowed to speculate within the limits of your expertise. Let's talk about expert witness for just a second. You are not necessarily called and defined as an expert witness when you come into court as a mental health counselor. But if you are there as a witness solely as a matter of fact, if your expertise is only there, if you're a witness there only to testify to fact, then you can make the argument that you cannot speculate or interpret on anything. You can only report. So if you are handing a report into the court, then all you can do is verify that that is your report. All you can do is read portions of the report. You cannot speculate. You cannot further advance information about your client's emotions, state of mind, mental status, any of those things, because those are requiring efforts that would be made by an expert witness who has skills and expertise which would come with an advanced degree, a license, or other qualifications that mean that they have special skills and knowledge that the court will use to further their testimony. So, I really encourage mental health counselors to assert themselves as expert witnesses. Otherwise, all you can do is say, yes, that is my report. Yes, those are the words I wrote. Yes, I made that statement. Begin to elaborate on it. Begin to elaborate on your client's experience. You're testifying as an expert. Behavioral, even cognitive observations are going to better fit with fact requirements of the court than emotional or inferred dynamics. So again, it doesn't mean that you can't present emotions or inferred dynamics, but you need to lay the groundwork for these. And your professional expertise is the background of the dynamics. I would show up to court with a curriculum vitae. So have your professional experience, have your educational experience in your resume or your CV. CV is a curriculum vitae with you and available to copies for each attorney and for the court so that can be entered into evidence if they want it. You may also find yourself in conflicting roles as the witness and the counselor or therapist. Do I advocate for the client's wishes, or do I testify as an objective observer? And the paradox here is that the most credible presentation in a judicial proceeding may be to present yourself as both an advocate and in an impartial manner. So you're bouncing back and forth between trying to be impartial, trying to explain what you observed, and then advocating for your client. So you end up explaining to the court your understanding of issues, but you come at it from your client's perspective whenever you can. You may end up needing to educate the court that you are aware of your role as a therapist. And you recognize that the client's view is not impartial, nor is it true, but the client's view is the one with which you work and the framework from which therapy occurs. So yes, you can step back and give an impartial view, but you're also going to provide the court with the client's view. And you are knowledgeable and aware that you're giving those two separate views. I can't tell you how many times I've seen counselors shoot themselves in the foot because the court knows this. The court is very aware of this, but the court wants to make sure that you know this. And so it becomes essential in some way, shape, or form that you let the court know that you are aware, your view and the client's view, and you're presenting the client's view in different times. Okay. Let's talk about confidentiality, privilege, and exceptions. As clinicians, we assume and have the responsibility to maintain confidentiality. No question about that. However, confidentiality per se can be difficult to define, particularly with the juvenile population. In Indiana, the juvenile has no right to confidentiality because a parent or guardian, and here you can also read the state or placing agent, does. So juvenile's confidentiality is really not held very tightly. If the placing agency gives up the right to confidentiality, the client's confidentiality is waived for a juvenile. Now, interestingly enough, the client may still have attorney-client privilege. And this is a right to confidentiality for information shared with the attorney. However, unless the attorney is working directly for the interests of the client, then privilege extends only to the guardian and not to the client. So, I've had situations in which a juvenile client witnessed a murder, another in which a juvenile client wanted to make restitution of stolen money. And in both cases, what I did to make sure that my confidentiality was protected for that juvenile, I had myself employed by the attorney who was representing, who then had me work with the client as an employee of the attorney. Under that situation, attorney-client privilege extended from me to the client because I was an employee of the attorney. Right? That's a little tricky, it's a little dicey, but it worked in those situations. I have also done therapy under the employ of the attorney. And in those situations, not only for juvenile clients, but for adult clients, anything that happened was under attorney-client privilege and could not be accessed otherwise. And attorney-client privilege is more ironclad than confidentiality. If you need it, and an attorney is willing to work with you on it, that is one way of making confidentiality even tighter. Courts have a very strong reluctance to violate attorney-client privilege, much so, more so than confidentiality, just for what that's worth. Let's talk about a subpoena for a second. Subpoenas are summons requiring the recipient of the subpoena to appear before a court or other hearing on a particular date, time, and place to give testimony in a particular case. Say it again. Subpoena is a summons requiring the recipient of a subpoena to appear before a court or other hearing on a particular date, time, and place to give testimony in a particular case. And that's your lecture question number 2. Subpoena can also ask you to bring relevant documents and records. And there are 3 actual advantages to subpoenas. Most people hate subpoenas, hate getting them. There are 3 advantages to them. First, they require testimony, and it makes you more objective than if you're voluntarily testifying for one side or the other. You're not just raising your hand and saying, hey, I'll go, sure, take me, I'll testify. You're being subpoenaed to testify. Somebody else is reaching in and saying, I want you there. All right. There's some protection from the claim then of the breach of confidentiality. And if you're subpoenaed, you can make the argument more logically that you're being asked to testify as an expert. If someone is asking you to come, you can make a more logical argument that I must be an expert because they're wanting me there. Some side thoughts on subpoenas and expertise. If an attorney seems to be too willing to drop a subpoena based on just your informal request, be careful, because a court order may be forthcoming. Think of a subpoena as a polite request, because that's really what it is. It's a polite request. A court order is exactly what it sounds like. The court is ordering you to appear. An attorney, actually anyone, but an attorney can subpoena you to appear before the court. A subpoena does not come from the court. A subpoena comes from a court officer, usually. The court can also issue a subpoena, but most of the time the subpoenas you get will be from the Department of Child Services or an attorney. When the court orders you to come, you come. You don't have a choice. You can technically be held in contempt of court for not responding to a subpoena. But in reality, that almost never happens. That's one of the reasons you could ignore a subpoena, although that becomes very irritating to attorneys. So, all right. If you don't respond to a court order, you are likely to face contempt charges. I had one subpoena one time that specified that I bring, quote, all materials, books, journals, and other pertinent professional references used to arrive at your conclusions in the psychological assessment regarding so-and-so to a deposition. I chose not to bring anything except the file, and the attorney was furious. But my argument in return was the deposition was too broad. Did they really expect me to bring my entire library, every journal article I'd ever read, everything from my educational experience? It was patently too broad to be realistic. So I just chose to ignore it. That was logical in that case, and nothing happened. All right. In another case, however, the court ordered my records without even stopping for a subpoena. It wasn't a broad subpoena, but the court ordered my records. And that was in a murder case. I didn't even bother to try to quash the court order. I would have had to have appeared in court. I would have had to have hired an attorney. I would have had to have made all kinds of efforts to preserve the client's confidentiality. And it just wasn't worth it to me to try to do it because I would have lost anyway. In a murder case, they would have obtained the client's mental health records. So I went ahead and just complied with the court order. Right? Different situation entirely. Go with it. Now, you do need to prep a client. If you're going to respond to a subpoena, if you're responding to a court order, you need to prep a client for what you may be asked on the stand and what you may need to say, because that may affect your relationship following the court hearing. So the client needs to know, at least broadly, what kind of things you may be saying about the client and how you'll be responding. And then get from the client, how are they going to feel about this? What are they going to think about what you're saying about them? And then there's the examination, the cross and the direct. And for a lot of counselors, not even the licensing exam is as bad as this. And I've spoken about it just briefly before. I was talking about the cross-examination before, more than the direct examination before, more than the cross. But the more formal the hearing, the more likely a challenge to the decision, and the more likely you are to find a hardball approach to both the direct and the cross. The direct is more likely to be in depth and to be sure and set the foundation and to go into excruciating detail about what you've done, how you've done it, what's been said, and the cross is more likely to be presenting you as a charlatan who never should have gotten your degree in the first place because you're such an idiot. Several tips on testifying in those situations. Don't be afraid to say, "I don't know." Counselors get into the position where they feel like if they say, "I don't know," they're going to look foolish. You're going to look more foolish if you try to bullshit your way through an answer and an attorney figures that out, because then they are going to go for the jugular and you are going to be lying dead on the floor as far as that answer goes, because they will lay you out if they know you are. All right? Nobody has all the answers to all the questions that are being asked, and that's okay. Again, the court sees that time and time and time again. So you're not doing anything the court hasn't seen repeatedly. Being professional. Being professional doesn't necessarily mean being stiff or rigid. You see people who sit on the witness stand like this. They look absolutely terrified. They look absolutely stiff. Unfortunately, actors do better in court. The ability to perform in front of a group, and it's similar to teachers, dramatists, attorneys. The best criminal attorneys, by the way, are great actors. If you really want to see somebody perform, a good criminal attorney in front of a jury is one of the best actors that you'll ever see. But if you can't perform, that is, if you can't put on a persona in the courtroom to cover your anxiety, don't fall into this wooden, self-righteous, distant way of covering your anxiety, because you can come across as arrogant, particularly when you're already on the witness stand. Instead, use those skills that you use in the counseling room. Use empathy, use insight, use reframing if necessary to understand the courtroom setting, and use it to your client's advantage. And avoid jargon. You don't need to talk down to the court, but there is a need to remember that terms such as adjustment disorder, post-traumatic stress, sexual abuse, terms like that have different meanings for us than they have for the lay public. I've actually had an attorney assume, while I was on the stand, that one diagnosis was not as bad as another because the number was lower. So, reading off my report, 2 diagnoses, one had a lower number from the DSM, and assumed that that was not as bad a diagnosis because the number was lower. And I had to take the time to educate about the meanings of those numbers. Answer what is asked fully, but don't answer any more. People get into difficulty when they start expanding on answers that don't need to be expanded. Answer what you were asked. Don't answer any more than that. And don't hesitate to consider answers. Dr. Cates, do you believe that this client will be a risk to her children if they are returned to her home? Based on my interactions with her, no, I do not. There's no harm, there's no foul in taking those few seconds to really consider that question. And I rarely answer yes or no. Some experts encourage this, just to say no. But my rationale in not answering yes or no is it avoids falling into the whole used car salesman trap. Isn't this a great color? Isn't this a great body style? Isn't this a great price? Can't you see yourself behind the wheel? Yes, 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 yes. You get into a series, and attorneys will do this with you. Attorneys will try to get you into a series of questions which you're answering in a certain way. And once they've got you in that pattern, they will try to get you to just follow right along. So, do you think she's a risk to the children? First of all, pause and really consider the question. Second of all, rather than just saying no, based on everything I've done, no. I was in a murder trial, and the prosecutor had a laundry list of the evils of the defendant, and he was asking me if each was true. And he obviously wanted me to respond positively to each, and quickly, since they were simple statements of fact. So he wants me to go, yes, 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 yes. And then build to a climax, which stated that, and shouldn't he be out of the, shouldn't he be put away so the public isn't at risk? I mean, that's where he was going. So I think the question was, how can you suggest a man such as this should not be in prison for life, was the question he ended up with. And I thwarted his efforts by taking the time to respond with much more than a yes, and disagreeing with some of the statements as too brief and too ambiguous. So I didn't, he would, don't you agree that someone who has a history of extreme violence will commit violence again? I agree that in most cases like that, there's a chance for greater violence, but part of it depends on the type of violence in the past, the duration, the frequency, how recent, lots of factors that a broad question like that can't take into account. For example, so rather than just yes or probably, kind of neutralize his question. And the interesting thing was, he summed it up for the jury as if I had agreed with him. So totally rang off what I was saying because he was so determined to get the answers he wanted to hear. Let attorneys lead with questions. Due to our history of interviewing, we may find this stifling. We want to set the pace. We want to call attention to untapped areas or whatever. Don't do that. Good, bad, or indifferent, the attorney is the one who is strategizing and implementing the legal plan of attack. And our job is to take a role in this overall plan. You can use notes to refresh your memory. There's nothing wrong with having notes on the stand. However, anything taken on the stand is fair game for either attorney to review. And again, this didn't happen to me, but years ago I had a friend who had taken her notes on the stand, and on the side of her notes, she had called a realtor about selling her house, and she had made the mistake of taking notes from that real estate call on the side of the client's notes, on the margin of the paper, and ended up explaining in court about the value of her house because an attorney took her notes, which was fair game, and asked her about what all these numbers were. Right? Anything you take on the stand is technically fair game to be used by the attorneys. So be aware of that. If you don't want the attorneys to read it, if you don't want the attorneys to have it, don't bring it on the stand with you. I keep all pertinent data with me in the courtroom, so it's available if it's requested and needed, but it's out there, in the courtroom in my briefcase, It's not with me. And of course, the cross-examination, which is sometimes aptly named, it's often used to challenge the credibility of a witness. And usually one faces indirect questions, but the cross will often jump to apparent inconsistencies in the testimony. Remember, any testimony has inconsistencies. When you're doing the direct examination, you may see places where the attorney has failed to tie things together. You may desperately want to tie those things together. Don't do it. Because what you tie together may cause more problems that you don't see. Tying those things together may not be important. That may not be what comes up on cross. You may not see things that weren't tied together. Whatever. Just let it go. What's important is not to lose your composure. Explain any inconsistencies as best you can and remain calm. And in some cases, the opposing attorney will work to establish doubt. And this is particularly true if it's a case in which, a criminal case, in which someone has to prove beyond a reasonable doubt that something occurred. One common way to do this is to prove that a set of facts or observations may have greater than more than one potential interpretations to them. Although it's those meanings, but it may be unlikely, but there's more than one meaning possible. The best way to handle that I've found is to simply agree. Hypothetically, doctor, is it possible that pigs could fly? Yes, it's possible, but unlikely in my professional opinion. So, I don't disagree. Hypothetically, all kinds of things are possible. Is it possible that this alternate interpretation is an interpretation? Rather than being depressed, could your client have been manipulating you? Yes, that's certainly possible, but unlikely in my professional opinion. Attorneys will also use the logic funnel. They ask a series of questions in which they try to squeeze the witness toward a desired response. And this is going to happen on direct as well. If the attorney questioning you on direct feels like you're not going where they want you to go. For example, I had a burglary hearing. There was a 15-year-old boy who was caught in the home by the mother, and she came home early, found this boy burglarizing her house, and she felt that the burglar, the 15-year-old burglar, had terrorized her and her infant son. Right. The prosecutor said, "Doctor, how much," and I was working for the defense in this case. Prosecutor says, "Doctor, how much time did you spend with the defendant?" And I said, "I spent about 2.5 hours doing the actual testing face to face." And he said, "And in that time you gave," he mentioned the psychological test, and I said, "Yes, I did." And the prosecutor said, "You were a busy man." And again, I said, "I was." So the prosecutor said, "Much of your time was spent administering these tests, was it not?" I again agreed, yes, it was. At least some of it. And he said, the prosecutor said, "So how, doing all these tests in this brief amount of time, did you really have an opportunity to observe or understand the client?" What a windfall. What a windfall. And it gave me a brief opportunity to discuss the process of interviewing, psychological testing, what was involved in psychological testing, and why psychological tests were used in the way they were used. So, again, taking an adversarial setting where he was attempting to push me into a corner and using it as an opportunity to educate. rather than becoming defensive. Intentional ambiguity is another technique they'll use, often created through compound questions, double negatives, and if you try to answer all at once, you'll become confused. So it's important to answer in pieces. I had a question once, and this was on direct. This was in a custody evaluation again, and the attorney said, "Are you aware that the mother has stated that she never told her friends or you that she intended to move with her son to a hotel in Indianapolis?" And in responding to that, I said, "Mr. I called the attorney's name, you have two different questions there. I have no idea what she told her friends. I only know what she told me." And I then responded to the part of the question about what she had told me. Sometimes there's a simple question with a complex answer. Isn't it true that a social worker, psychologist, mental health professional has a long way to go in explaining behavior? And you can answer that by defining the question as complex. That's a complex question. And then respond with gains in understanding behavior, cognitions, emotions in the field, and the vast uncharted territory ahead of us. So, do we have a long way to go? Absolutely. Do we have a tremendous amount of data that we understand? Absolutely. But just like medical science has tremendous understandings, but medical science has a long way to go. So, very much like our compatriots in medical science, yeah, we're in the same boat. Also note that unless you're in front of a jury, responding here to define your own credibility is not to educate the judge or the attorneys. They know. They're waiting to see if you'll admit it. That's really all it's about. They know the credibility of the fields. You don't have to do that. One of the most difficult, long, and protracted directs, cross, redirect, and redirect that I've ever had came about because of a very simple assessment on my part and an issue which was not mine. Had a man who was mildly intellectually disabled, would have called him mildly mentally retarded at the time, who had signed off on paperwork accepting a plea agreement while he was in jail. After he had signed off on the plea agreement, he became upset and said, "I didn't understand what I signed." What had happened was that the prosecutor had sent the paperwork over to the jail. The jailer had given it to another inmate who read the paperwork to him, and he signed it based on what the other inmate told him was in the paperwork. I assessed him and agreed he did not have sufficient reading level to understand what he had read. He could not understand it himself. He could not comprehend it himself, and was sufficiently intellectually limited that he would have had to have had a very thorough understanding of that paperwork explained to him to really grasp the plea agreement he was being offered. The question then centered on whether the plea agreement could be accepted once he had accepted it without understanding what he was doing. It became a nightmare of questioning me about whether he could comprehend that he was accepting something he shouldn't be accepting. It was back and forth and back and forth and back and forth, and very heated at times. But all I had to present was very simple. And yet that was one of the most difficult ones I've done, because no, he could not understand. When we get into the technicalities of what the legal system is required to provide for him in terms of understanding that, that's totally out of my range of expertise. And that's where they kept wanting to push me, and that's where I kept having to say, I don't know. I don't know. So sometimes things, again, you don't know what's going to happen in a courtroom. Some questions are designed to imply impropriety. The question will come up, have you spoken to anyone about your testimony today? Well, absolutely I've spoken to someone about my testimony today. It's absolutely appropriate to discuss one's testimony with supervisors, with attorneys, whoever, and to say so. It is not appropriate to be coached on how to slant, manipulate, or otherwise distort your testimony. But to discuss it, to discuss what you're going to say, to discuss the relevance of your testimony, to discuss relevant portions, absolutely. Yes, you can't be coached. And that's lecture question number 3. Have you spoken to anyone about your testimony today? It's absolutely appropriate to discuss testimony with supervisors or attorneys. It is not appropriate to be coached. So let me just give a word on court in the big picture here. When we see court as a nuisance, an occasional experience that has to be managed, we fail to see the big picture of what we're doing. For many of our clients, the court system is a part of their lives. Review hearings, probation hearings, meetings with caseworkers and probation officers that can at any time lead to a court hearing are part and parcel of their experience. And when we convey to clients, even indirectly, our disdain or our discomfort with court, we convey to them the fearfulness of the system. And it can be fearful. There is no question about that. But our opportunity is to instill a sense of compassion in the judicial system. It's not easy to do. It requires practice, it requires a sense of timing, and a development of confidence in oneself, but it can be done. I had a court hearing a number of years ago where there was a question of where to move a resident of a residential center. She was making no progress where she was, and the question became, should she go to a less stringent placement? And their psychologist and I disagreed. We're both in court to testify. The mother and father and the child are also present. And I had the opportunity to say in open court, Your Honor, I believe I'm right, but no one knows for sure. And we have to fundamentally disagree. We have to fundamentally agree that the current treatment is more harmful than helpful. And I wish I had a crystal ball, but I don't. And given that, both Dr. So-and-so and I are working in the best interest of the child. And it turned the tensions in the courtroom. It made things less tense. And everybody got on the same page about working toward really a treatment team approach in a court hearing, which was wonderful to see. And we hammered out a compromise that I think at least tried to meet the needs of this child and got the parents back on board with the residential treatment center. You know, if you just take it as a horrible thing that has to be endured and gotten through, if you don't take your position as an advocate, you miss that. The bottom line here, we don't have to sell out our values in the helping profession to appear and testify in court. All right. We are done with lectures for this semester, for this session. I hope you have gained from this, and I hope as you wrap up your time at Purdue Fort Wayne and move out into the field, I have a chance to meet some of you face to face. That's really been my greatest frustration with the way this semester has gone, is the lack of opportunity to really meet you. So let me know if once you're out in the field that you took this course and know me. Take care. Good luck with your professional careers, and I wish you well. Bye-bye.